Students, we are starting on with the corporate law session for the CA final. Today, we are going to start on with the appointment and qualification of directors chapter. One of the primary chapter which you all should learn for the profession of chartered accountancy itself, this particular topic. The first unit which you are going to learn is appointment and qualification of directors. Now, under the appointment of directors by virtue of section 149 of the Companies Act, I am going to tell you what should or who should be appointed as the director of the company. The first thing which you are going to see at this juncture is only individuals to be appointed as the director. Every company shall have a board of directors consisting of individuals as directors. Every company shall have board of directors consisting of individuals as directors. Now, we need to learn certain terminologies at this juncture. What is meant by board of directors? Every company, then the terminology used is every company. So, it is not applicable for a specific kind of a companies alone, it is applicable for all the kind of companies. So, that is why they use the word every company. Every company shall. There are two words in law, one is shall, another one is may. When the word shall is used, it means it is mandatory. When the word may is used, it means it is discretionary. There is a topic called interpretation of statutes. In the interpretation of statutes, we should learn that certain words need to be used in the law. That words should be interpreted in the manner which has been implied so. For instance, as a use shown in the words shall and may. The word shall implies mandatory. The word may implies directory. So, appointment of a director is a mandatory provision. It is not a voluntary provision, it is not a directory provision, it is not a discretionary provision, it is a mandatory provision. So, every company shall have a board of directors. What is meant by board of directors? Sir, directors are individually called as director, collectively called as board. For grape, what we used to say, bunch of grapes. For sheep, what we used to say, flock of sheep. Like that, for director, the collective terminology is nothing but board of directors. Every company shall have board of directors consisting of individuals. So, at this juncture, we need to be very clear that the individuals only can be appointed as director. That means human. Only natural person can be appointed as director, artificial person cannot be appointed as director. Company, trust, firm, all those things cannot be appointed as director. I have given this here. This section enunciates that legal person or any other association or firm cannot be a director of a company. Only a natural person can be a director of the company. Okay. So, we are very clear that who can be appointed as a director, only an individual can be appointed as a director. Firm, company, LLP, trust cannot be appointed as a director. Okay. So, again I tell you this, the word used is shall. Shall means it is a mandatory provision. Is this section applicable for all the companies? Yes, it is applicable for all the companies. The section uses the word every. Okay. So this is the primary provisions with respect to the 149(1). I am showing you again this section. Every company shall have a board of directors consisting of individuals as directors. This is the primary provision. What I have shown you, this is an explanation of this section. Okay. 149(1) says this only. Every company shall have a board of directors consisting of individuals as directors. Okay. I hope you are clear, friends. I am going to the next provision now. Now I am saying, what is the minimum number of directors? Because we all know that a company cannot have 100 directors. The first thing which we all should know is why a director is required. Director is an agent of the shareholder. Let's say a big, huge company, Reliance, Tata, Wipro, Infosys. How many shareholders will be there in that company? There are lakhs of shareholders. Reliance have more than 10 lakh shareholders. If every day morning shareholder says that they are owners, and if they come into the company and start working towards the company will destroy. The reason is everyone cannot control the company just because they are the owners. So they appoint some agents on behalf of them. They are called as directors, and they will regulate the affairs of the company. At this juncture only, we are going to understand what is the minimum number of directors required. The minimum number of directors required is given in section 149, subsection 1, clause A of the Companies Act 2013. Every public company shall have at least 3 directors. Private companies shall have 2 directors. 1-person company shall have 1 director. Friends, I am again repeating. Public company shall have 3 directors. Private company shall have 2 directors. And 1-person company shall have 1 director. This is a minimum number of directors. Okay, I am not saying this should be restricted to this, but the minimum should be this. If this is not there, then this is the contravention of the law. This is a violation of the law, because minimum 3 directors should be there in the public company. Now there might be some questions or doubts which might arise in your mind, because you all would have passed your CA Inter and you would have come to the CA final now, and CA Inter you might have learnt a provision that in the Companies Act, sir, subsidiary of a public company is also a public company. If there is a private company, if it is a subsidiary of a public company, then for that private company 3 directors is required or 2 directors is required. You will have this doubt. A private company which is a subsidiary of a public company is deemed as a public company. For that private company, whether 3 directors is required or 2 directors is required, because we are seeing 2 provisions here. For public company, it is 3 directors. For private companies, it is 2 directors. Now at this juncture, for a private company which is a subsidiary of a public company, what is the minimum number of directors required? The minimum number of directors required for a private company which is a subsidiary of a public company is only 2 and not 3. Okay? On certain aspects only it shall be deemed as a public company, and we need to follow the provisions of the public company. And for a 1-person company shall have only 1 person. I am going to the next provision now, friends. What is the object behind this provision? That's what my next thing. See, leave the 1-person company, there is only 1 person is going to be there. It is a legalized corporate form of a sole proprietor is 1-person company. Think about a public company and private company. Why the minimum requisite is 3 or 2 and not 1? There should be a dual control. That is the logic behind that. At least 2% should be there to control and manage the company. That is the reason why they have kept it as dual control. Okay. So look at here, I have given the object. The object of the section is to provide a dual control in the management. The Act also provides number of provisions designed to ensure that the office of the director does not fall into the same hands in the companies with only one director. Of course, OPC is an exception. In practicality, if you have already seen in your articles time, there might be a different opinion you might have formed by this time. The reason behind this is there will be a private company, small private company. Who will be the directors? Husband and wife. Wife will never come into the company. Only husband will be controlling the company. So then why this provision? Friends, what we learn in the law is sometimes theoretical, substantive provision that cannot be applied in practicality. And we are not sure that it's always husband controls the wife, it is wife only controls the husband. So you need not take it in the practicality, sir, only husband controls the company, but wife controls the husband itself. So don't worry about that aspect. What we are learning is a law. If law says 1 plus 1 is equal to 3, we need to smile and accept. Okay? Because it is law. So with this being the provision given here, every public company shall have 3 directors, private company shall have 2 directors, 1% company shall have 1 director. This is the minimum number of directors. Okay? I am going to the next provision now. What is the maximum number of directors? The maximum number of directors provision is given under the Companies Act. The maximum number of directors for a company shall have a maximum of 15 directors. So one company can have maximum 15 directors. Can I have more than 15 directors? That comes the next question. Yes, you may have more than 15 directors, but you need to fulfill certain formality or certain procedural requirement in order to have more than 15 directors. What is the procedure I need to fulfill in order to have more than 15 directors? That comes the question. I need to pass a special resolution in order to have more than 15 directors. What is that special resolution? Special resolution is a decision taken by the shareholders. How much the decision should contain of, what is the voting percentage it should contain. The voting percentage the director should give in case of the special resolution is, shareholder should give in case of the special resolution is 75%. At least 75% of them should give their consent in order to pass a special resolution. So, with respect to the special resolution provision, 75% of them has to give their consent. A company shall have a maximum of 15 directors, more than 15 can be appointed after passing a special resolution. So this section ensures that the number of directors are not out of proportion. What is that out of proportion? A company can have maximum 15 directors only. For that, more than that, you need to pass a special resolution. Okay? A company having 2 members, 40 directors, looks hilarious. Just 2 members are there, private company, 40 directors. What will you do with the 40 directors? At the end of the day, company will never make a profit at all. They will be giving only salary for the directors, sitting fees for the directors. All the 40 directors will have 40 opinions. So have a less limited directors so you can run the company efficiently. You need not have so many directors to run the company properly. Have a limited number, that's sufficient. That's what the law is saying that. So the purpose behind the section, this section ensures that the number of directors are not out of the proportion to the size and the nature of the business. Whether the business requires this? No. Whether the proportion of the size, member is less, director is high, whether it is required, that's a case here. It is interesting to know that under this section, it's not only public companies should appoint 15 directors. It is not only private companies should appoint 15 directors. Even your one-person company can appoint 15 directors. Okay? One member will be there, 15 directors will be there. Please understand, directors are agents, are servants of the member. So, in one-person company also, there can be 15 directors. I hope you understood this section, which talks about the individuals only can be appointed as directors. Minimum directors in case of public company is 3, private company is 2, and in case of the one-person company is 1, and maximum directors is 15, and you can appoint more than 15 directors by passing a special resolution. I am going to the exemptions for the section. In case of a Section 8 company, or do you remember Section 8 company? You might have learnt long back when you were in foundation time or in your inter time, you might have learnt this, friends. What is a Section 8 company? So, Section 8 company is a company which is association not for profit. Association not for profit company, very popularly called as Section 8 company or licensed company. That company, there is an exemption. What is that exemption? The minimum number of directors is not applicable to Section 8 company, and it can appoint more than 15 directors without passing a special resolution. So, minimum number is also not applicable, maximum number is also not applicable for the Section 8 company. In case of the government company, friends, government companies are not in our hands, please understand, it is regulated by the government. So, government itself has given exemption for the government companies. Okay? Who makes the law? Government makes the law. Whether government will apply that law for the government company? Obviously no. So, government companies are exempt from this provision. So, some of the provisions of this law are exempt for the government companies. Wherever it has been exempt, we will learn it where it has been exempt. Okay? So, one of this provision is this, the minimum number of directors and the maximum number of directors is not applicable for the government companies. It can appoint more than 15 directors without passing a special resolution. Okay? So, we will go into some questions for the purpose of this topic. As per the articles of association, the maximum number of directors of each of the following companies is 9. Good Heart Company Limited, Frontline Trading Private Limited, Hindustan Zinc Limited, a government company. The board of directors of the aforesaid company proposes to increase the number of directors to 15. Advice as per the Companies Act provision. What is the requirement now? They want to increase the number of directors to 15. What is the existing? 9. So, existing is 9. What is the proposed? It's proposed is 15. Okay. For Good Heart Company Limited, they can appoint, it's a public company, it can increase up to 15. There is no prohibition for the purpose of the law, they can appoint up to 15. But what is the problem here is articles of association says only 9. So, what should I do? I should alter the articles of association in order to make it to 15. Okay. So, pass a special resolution, alter the articles pursuant to section 14 of the Companies Act 2013, and then you can go ahead with the 149 and appoint the directors. Frontline Trading Private Limited, again a private limited company, alter the articles and you can appoint. And for the third one, same as the answer, alter the articles and appoint. In all the 3 companies, it can be appointed up to 15. As the articles says so, you need to alter the articles and say that maximum number of directors can be 15. That's the answer here. I hope you understood. Yes, friends, good. I am going to the next section now, number of directorship section. In how many companies a person can be a director? A person can be a director of maximum number of 20 companies, he can be a director at the same time. A person shall not hold office as director, including alternate directorship in more than 20 companies at the same time. Okay. So, a person can be a director of maximum of 20 companies only. Okay. Of the 20, he can get appointed in public companies 10 of the 20 companies, the maximum number of public companies he can get appointed 10. So if I say 20, I put a chart like this for your understanding. In public, he can get appointed in 10. In private, he can get appointed in 10. Okay. There is a restriction only for public company, there is no restriction for the private company. I will show you some other illustration. This is case 1. In case 2, I am showing you, can he get appointed in 8 public companies and 12 private companies? Affirmative, yes. Because private company, it can be more than 10, public company only maximum 10. I will give you a case 3 illustration. In public company it is 0, in private companies 20, it is allowed, yes it is allowed. My case 4 is 0 private companies, 20 public companies not allowed, only 10 is allowed. 10 in case of a public company is only what allowed under the law. Okay. I hope you understood this section. The maximum number of directorship cannot exceed 20 at the same time, but in a public company it cannot exceed beyond 10. This section shall not apply to a section 8 company which has not committed default in the filing of the financial statements and annual returns. So this section shall not apply to a private section 8 company which has not defaulted in the filing of the financial statements and annual returns. The maximum number of the directorship for reckoning that limit, the 20 companies, dormant company shall not be included. Okay. So company itself is dormant. Then why for that company the directorship should be included? The company is an inactive company. The company is a non-operative company, that is called as dormant. Okay. In normal English, dormant means lazy. In legal language, dormant means it is inoperative, which is not an active business right now, that is called as a dormant company. For the dormant company, this section is not applicable. So I am director in 20 company. In 21st company, in the dormant company, I am a director. Have I contravened the provisions of this law? Have I contravened the provisions of this law? No, I have not contravened the provisions of this law. Okay. For reckoning the limits of a public company in which a person can be appointed as a director, the directorship in private companies that are either holding company or subsidiary company of a public company shall be included. Friends, very interesting provision this is. If you look at the provisions of the Companies Act from the perspective of the public company and private company regarding the subsidiary provision, what we have learned all these years, a private company which is a subsidiary of a public company is also treated as a public company. That's what we have learned. So here they use the word subsidiary. It's taken. I completely agree, because public company's subsidiary, which is a private company, which is also treated as a public company. But they go further in this section and say that the holding company is also treated as a public company's computation for this section. What you will do, I am already a director of 10 public companies. I want to become a director of the 11, it's a public company. So intentionally what I do, I cannot become a director of the 11, it's a public company. I start a private company is the holding of that public company. So I become a director of that private company and I will control the public company. So law says that what you cannot do directly, you cannot do that indirectly. What is that? What you cannot do directly, you cannot do that indirectly. So you cannot become a director of the private company which is also the holding company of a public company is provided. The restriction can be imposed by the members under section 165 subsection 2. That is, if you are a director of more than 5 companies, you cannot become a director of my company. Suppose there is a company called X Limited. X Limited says that if you are a director of more than 5 companies, you cannot become a director of X Limited. Mr. A is a director of 7 companies. Can he become a director of X Limited? No, he cannot become a director of the X Limited because he is already a director of the 7 companies. Okay, you got it, no? So this section is applicable for private company which is a holding and as well as a subsidiary. Okay. So for specifying a lesser number, the company should specify through a special resolution. A special resolution should be passed. Just now I taught you what is special resolution in the previous section 149. What is the required percentage? 75%. Yes, you are all got it right. 75% is required for passing a special resolution. Okay. There is a penalty provision for this section, where the penalty provision is if a person accepts an appointment as a director in contravention of this section, that is more than 20 companies, he shall be liable to penalty of 5,000 rupees for every day. For each day he is occupying the office in more than 20 companies, he will be liable. For instance, 1/9/2020, he is occupying office in 20 companies. 2/9/2020, he is getting appointed in 21st company. He vacates the office from the 21st company on 2/10/2020. Vacates in 21st company. Now, for 1 month, 30 days, he has been a director of one more company extra. 1 day 5,000 rupees, 30 days 5,000 rupees for each day, he need to pay a penalty, then only he will be relieved from the non-compliance of this section. Are you getting it? Yeah. So we are coming to the question of this particular provision. Mr. Influential is already a director of 19 companies. Out of this 19 companies, 10 are public companies. Okay, maximum public company you can be director is 10. How many companies is a director in private? 9. 9, 10. Mr. Influential is being appointed as a director of another company named Expensive Remedies Limited. Friends, it says Expensive Remedies Limited. Limited alone is used, that means it's a public limited company. Okay, how many companies is already holding? 10. 10 plus 1, 11. How much he can maximum hold? Only 10. This is a contravention of the section 165. Advise Mr. Influential in regard to the following. So restriction on number of directors should to be held by an individual. Whether he can accept the new appointment in the view or thereof. No, he cannot accept the appointment in Expensive Remedies Limited. He should hold maximum of 10 only. Hence, this is a contravention of this section. What are the companies to be excluded for the purpose of calculating the ceiling limit for the appointment? We saw this, no? The ceiling limit provision is concerned. Section 8 companies which has not defaulted in the filing of the financial statements and annual returns is exempt. Dormant company is exempt. Okay. Will your answer be different if he is getting appointed in ABC Private Limited instead of Expensives Limited? Yes, sir. Because private limited company 10 is allowed. Already 20 is there. 20 minus 19, one more company he can get appointed. That one company is private company only he can get appointed. He cannot get appointed in the public company. So we are going to the second question. Mr. Raj is a director in 10 public limited companies as on 30th July 2019 and continues to be so till 21st September 2019. Following companies appoint Mr. Raj as a director at their respective AGM held on dates mentioned against their names. MLP Limited AGM held on 27th September 2019. PAT Private Limited AGM held on 25th September 2019. Retail Traders Association AGM, which is held on 26th September. Please understand, Retail Traders Association, the Section 8 company, hence it is exempt. Okay, if you look at the previous slide which I showed you, this previous slide shows that MLP Limited is a public company, PAT Private Limited is a private limited company, the year maximum 10 only, this is also included for maximum 20, but Section 8 company will not be taken for consideration. The fourth one is public limited company, maximum 10 taken for the consideration. Okay? You are required to state with reference to the 11 provisions of the Companies Act 2013 the options available to Mr. Raj in respect of accepting or not accepting the appointment above. So you need to say whether 20 is satisfied, whether 10 is satisfied in case of public, all these factors should be taken into account. For the third case alone, Section 8 company, it is exempt. Okay? So the last section for the unit 1 I am coming into, duties of director, section 166. Okay? These are all the motherhood provisions of corporate governance. Previously, under the 1956 Act, there were no duties for the directors. All these were common law provisions. Now, the law itself states what are all the duties. He should act in accordance with the Act and AOA. So, director should act accordance with the Companies Act 2013 first, and he should also act accordance with the Articles of Association. He should act in good faith. A director of the company shall act in good faith in order to promote the objects of the company for the benefits of its members as a whole and the best interest of the company, its employees, shareholders and community for the protection of the environment. Today there are so many cases. Pollution is caused by the company does in the chemical manufacturing, pollution. Now Companies Act says the director should ensure environmental protection. Okay? Care, skill and diligence. A director of a company shall exercise his duty with due and reasonable care, skill and diligence. It's a duty of the agent, no? He should always act in the care, skill and diligence of the company. He should not conflict with the interest of his personal interest with the company's interest. Okay? When he becomes a director of the company, his interest should not override the company's interest. A director of the company shall not achieve or attempt to achieve any undue gain or advantage either to himself or to his relatives, partners or associates. This is very, very important critical aspect of corporate governance. Today directors, if you see in bigger companies, who is getting appointed in the company, if you look upon his own kith and kins, son-in-law, mother-in-law, father-in-law, these people only regulate the companies. Okay? So in order to avoid this only, the law says that you can appoint them, but don't gain out of the company in an unfair manner. Don't achieve or attempt to achieve for any undue gain. Due gain allowed, undue gain not allowed. If such director is found guilty of making any undue gain, he shall be liable to pay an amount equal to that gain to the company. So if you have earned anything from the company, pay that to the company. Okay? Undue gain, if any, give it back to the company. The last provision of the 166 is this. A director of the company shall not assign his office, and any assignment so made shall be void. Okay? Friends, I told you very in a blatant language, I told you that. Who is a director? Director is a servant. Who is the owner then? Shareholder is the owner. Director is the servant. Okay? Agent. You yourself is a servant. Servant appointing another servant, how logical it is. Okay? For servant's house he can have a servant, but In the place of owner, servant appointing a servant for himself and doing a task is not allowed. That's what law says, that a director of a company shall not assign his office. Okay? So he should not delegate his work to another person. In Latin there is a word, delegatus non potest delegare. You yourself is a delegate, so you should not delegate it to others. Okay? So penalty of this section is, if the director of the company contravenes this provision, the director shall be punishable with fine which shall not be less than 1 lakh rupee, but which may extend to 5 lakh rupees is the penalty. Okay? We will see a small question in this regard, friends. X was appointed as a director for the life by the articles of the association of a private company incorporated on 1st June 2019. The articles also empowered X to appoint successor. The X appointed by will G to succeed him as after his death. Can G succeed as a director after the death of the Can G succeed X as a director after the death of the X? That comes a question. Okay, friends, we need to go back to 166 for a minute and look at this provision. There is something which I have given as a star mark, is this word, cannot appoint, cannot assign his office. In the given case of the question which I have given to you, after the death of the director only it goes to his successor. So he is not assigning his office because he has died. At the time of the assignment, he should be alive, then only it's called as assignment, his office. He himself has vacated the office. So this section will not fall within the purview of assignment of office. It is allowed. Okay. Friends, we have learnt 3 critical provisions in the unit 1. What are all the 3 critical provisions we have learnt? The first one is individual can only be appointed as director, minimum number of directorship, maximum number of directorship, and also we have learnt the duties of directors a company can have. Thank you, friends, for the first lecture.